The announcement follows a Supreme Court decision Friday allowing the rule to be applied in all 50 states. Supporters praise the new rules for easing some strain on expensive public assistance programs.
We're not talking about undocumented immigrants. These are people who are trying to obtain permanent status in the United States. And if they are struggling financially, these new rules will make it much harder for them to stay.
In this video, we're going to talk about this year's historical green card changes that relaxed many old rules and indicates for automatic green card movements.
Visit us at Swat&Vee channel with your questions to see how best we can help you out your process. Please don't forget to subscribe if you're new to the channel.
So, without any further delay, now let's get into the video and find out what the latest updates are on U.S. immigration. Welcome once again.
It's a rule that is designed to constrain legal immigration by reducing the number of people who are eligible for green cards and other visas. It's called the Public Charge Rule, and it determines how many public benefits an immigrant can use before their application for legal status is denied.
About 500,000 immigrants apply for green cards each year. Under these new rules, the vast majority could be at risk of being denied permanent legal status. Not affected, people who already have green cards, pregnant women and children, and refugees and asylum seekers.
As a direct result of this modification to the rules, the USCIS has formally revised the green card application forms. The U.S. Citizenship and Immigration Services, USCIS, has revised Form I-485, the application to register permanent residence, often known as just status, as well as the instructions for the form. You can submit an application for lawful permanent resident status, often known as having a green card, using this form if you are already physically present in the United States. The I-485 form and its accompanying instructions have, for the most part, remained unaltered for many years. Because of these modifications, each of the four is now easier to use. Additionally, the instructions have been improved to make them more useful and simpler to comprehend. Let's have a look at some of the new things that have been included. But before we go any further, could you kindly give this video a thumbs up so that the YouTube algorithm may find more videos on immigration that are helpful and recommend them to anyone who is interested in this subject? Let's get on with the new regulation that was issued by the Biden administration. Who, exactly, is included in the scope of this extended rule? Because of this, I believe that realizing that it does not affect the vast majority of immigrants is the single most crucial thing to keep in mind. The overwhelming majority of immigrants are not affected in any way by this rule. Persons who have been granted humanitarian visas, persons who are seeking asylum or who are refugees, and people who are in the country because they were victims of crimes or victims of human trafficking are all safe and will not be affected by the government shutdown. People who already have their green cards are secure from deportation as long as they do not leave the United States for a period of 6 months after they receive their card. This is the second most crucial item. Therefore, this does not have any impact on citizenship. So, how are things being done differently now compared to when the old norm was in place? To apply for a green card from within the United States after the 23rd of December, 2022, all applicants will be required to submit an updated version of their 485 form. That is the application for changing one's status to one holding a green card. Using this form, the government is gathering a significant amount of brand new information for the very first time. Which kind of public advantages are included in this revised definition? So, that is also pretty limited in scope. People have the impression that they will gain access to a wide variety of advantages by purchasing this product. Let's talk about it, shall we? The first step is to make an effort to strike a balance between your income and assets and your debt. Your financial obligations to the government have never been brought up in the past. The updated version of Form I-485 asks you to provide information regarding the amounts of your income, assets, and debts. You will be required to record certain categories of debt, including house loans or mortgages, loans for vehicles, loans for education, and loans for commercial or small business ventures. Although revolving debts such as credit card balances and subscription fees are less relevant in this context, you are nevertheless required to record them if the total amount is significantly more than $10,000. The second thing is that the government is interested in learning about your education, abilities, and other qualifications. You are now obligated to reveal the greatest degree of education you have obtained, along with any professional certificates and work experience you have. The government can use this information to evaluate whether or not you are likely to be employed and in what occupation you might find work. Your utilization of public benefits, particularly monetary advantages obtained from either the state or the federal government, comes in at number 3 on this list. In addition to this, the government will inquire as to whether or not you have ever been hospitalized on the dime of the United States government. The use of these public benefits is frequently limited to citizens of the United States or their immediate family members. The receipt of these benefits by a person who is neither a citizen of the United States or a permanent resident can now have a negative influence on an immigration application, even in cases where the government does not restrict their use. What does this imply for the status of your application for a green card? In the past, the United States Citizenship and Immigration Services, USCIS, did not operate in a transparent manner on their decision-making process for laws of this nature. The public can now receive some direction from the federal agency regarding what counts toward the benefits section and what does not count in the section. For instance, getting free diagnosis, immunization, and treatment for COVID-19 doesn't classify as having the virus. After that, the instructions for the new form, the United States Citizenship and Immigration Services, USCIS, says that you do not need to include any extra proof to substantiate the information that you supplied in the new part of the application form. On the other hand, if the agency is interested in viewing the supporting paperwork, it may submit a request for proof. Be as truthful and thorough as you can in all of the information that you submit to the government in an official application. In some circumstances, the presence of any omissions or contradictory facts may constitute grounds for a request for further information, RFE, or a refusal. Let's move on to the next topic, U.S. to issue green cards automatically. This provision for an automatic green card will only be available to a very specific category of immigrants. Therefore, I believe that realizing that it does not affect the vast majority of immigrants is the single most crucial thing to keep in mind. The policy document governing these automatic green cards has been brought up to date by the United States Citizenship and Immigration Services. There will be a total of 400 successful applicants to receive it. The applicants in question will now be granted automatic renewals of their green cards for a period of 24 months. In the past, they were required to submit their applications manually using 4 of I-551. Any of the 400 applications that were submitted on or after December 12, 22 are eligible to receive the new policy modification that provides an applicant with an automatic extension of their green card. According to the notification of receipt, the person's green card will continue to be valid for an additional 2 years after the expiration date that is indicated. As a consequence of this, the applicant is able to cite both the green card that has since expired and the notice that they have been paid the required $4,000 as continuing evidence of their status as a lawful permanent resident. This includes for the purpose of establishing that you are authorized to work and travel. Because of this change in policy, the United States Citizenship and Immigration Services should be able to alleviate some of the pressure placed on many applicants for the Form 400. In the past, these applicants would have been required to also submit Form 480 and pay yet another filing fee to the USCIS. As a result, USCIS employees won't have to spend as much time as before adjudicating these 90 applications, which should help free up additional resources there. It is always a good idea to download the immigration forms from the U.S. Citizenship and Immigration Services website. This is due to the fact that the immigration forms are always being updated.
I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!